And you wouldn't want a skilled SARS auditor after 10 years, for instance, to remind you that you signed that declaration
Correct.
and put into question all the tax returns that have been filed subsequent to your exit
Mm.
on a non-resident basis, albeit only declaring local sourced income under FE. SARS could then challenge you,
Mm.
and you open yourself up to the risk of back tax.
Mm. Good morning to all viewers, and thank you so much for joining in on today's episode where we will be cracking the code, seeing that it is the filing season. We will be navigating all things DTA, how to navigate it as a South African living and working abroad. Now, without any further ado, I will be introducing one of tax consulting's astute and seasoned tax attorneys, as well as legal manager for the cross-border taxation, Delano.
Good morning, Mbalenhle, and thank you very much for having me today. I look very much forward to giving as much insight to our viewers as possible.
Thank you. Thank you so much for your time. I know you're a busy man. Without any further ado, I think we're going to just have to lay the foundation on explaining exactly what is the South African tax residency system, how it works, and how or why one's tax status matters.
I think a very good starting point is recognizing that South Africa works on a residence-based tax system.
Mm.
And without identifying a specific date, since 2001, the Income Tax Act has two categories of what a taxpayer's status can be for residency. This meant that when one registers for personal income tax in South Africa, they need to be viewed as either a normal resident taxpayer, alternatively a non-resident taxpayer.
Mm.
One cannot hold both statuses at the same time, so this then makes it very crucial for one to navigate what status do you hold and what are the applicable tax years which makes you either resident for filing purposes or non-resident for filing purposes.
Mm. Okay. No, I know with a lot of, clients in practice, we do know that there are double tax agreements. But how do double tax agreements work, and what is a double tax agreement?
So in its very simplest form, a double taxation agreement is a contractual document between two contracting states. What's important to note is that South Africa is a country that has a vast number of double tax agreements with tax jurisdictions across the world,
Yeah.
which makes South Africa quite attractive for purposes of tax planning.
Mm.
In terms of the agreement, it deals with a variety of tax issues,
Yeah.
as well as different tax types. Key in this conversation is that most double tax agreements, not all, have a specific mechanism where one can navigate exclusive tax residency in one jurisdiction in favor of another. And this is a very important mechanism for expats in particular,
Yeah.
who are concerned about double residence having a bearing on double taxation. So in other words, being taxed by two countries on the same income.
Sure. Okay. Now, even though you mentioned that certain countries do have double tax agreements, not all countries, from my understanding, does this mean it's automatically applied? How does one make sure that they are protected by the double tax agreements?
So double taxation agreements do not apply automatically. A very good saying, I think, is that a taxpayer cannot resort to a self-assessment
Hmm.
of their tax affairs, including their tax residency status for that matter. This means that it's important for taxpayers to give the Revenue Authority an opportunity
Yeah.
to verify their requests. If, for instance, they elect to hold a non-resident status in South Africa
Hmm.
based on a double tax agreement.
Okay. All right. This might be off, but what happens to those expats living and working abroad and they find themselves in a country that is actually not protected by the double tax agreement? How do they ensure that their foreign income is then protected?
Well, this is a very difficult one for those particular expats
Mm.
because it might be that they were not aware South Africa did not have a double tax agreement
Yeah.
with the country they've relocated to. Key is we come back to the filing of tax returns.
Mm.
So the question is, have those taxpayers been filing their tax returns in South Africa?
Yeah.
If they have they been doing so on a resident basis or a
Yes.
non-resident basis?
Mm.
It would be very difficult to believe that they could file it as a non-resident
Mm.
using a DTA that's not in place.
Yes.
If, however, they still wanted to be a non-resident, it may be that they financially immigrated from South Africa.
Mm.
That could be a qualifying basis to make them eligible for non-residency.
Yeah.
But if they haven't done that, it's again important to understand what is the basis on which one claims to be a non-resident in South Africa.
Yeah.
Because SARS is not eager to make every individual taxpayer a non-tax resident. They lose out on collection of tax for foreign sourced income
Mm.
for every individual who becomes a non-resident.
Mm.
So this is also perhaps a discussion of each country fighting for their own taxing rights
Mm.
and to ensure that they can collect tax on what is legally due to the Revenue Authority.
Yeah. I think further to that, to touch on something which we did see that in the later part of July, precisely the 28th of July, SARS did issue a notice, in particular for non-residents, to say they need to ensure that they are either protected by the DTA or Financial Emigration, if I'm not mistaken, especially when it comes to filing their tax returns. Maybe if you can just emphasize on the importance of declaring of foreign income during this filing season in particular, because we are seeing that SARS is very stringent on knowing whether a taxpayer is filing correctly as a tax resident or non-resident.
Absolutely. I think if we go back to your initial question around what are the two statuses,
Yes.
let's start off with being a resident. For so long as I am a resident taxpayer in South Africa,
Mm.
registered for tax and have a filing obligation, I should declare worldwide income.
Yes.
Those individuals who receive income and are still living and working in South Africa, they would normally just declare local sourced income.
Correct.
There wouldn't be foreign sourced
Mm.
income. The moment one is an expat, however, so an individual living and working in a country other than their home country, in a
Mm.
very simple explanation, they would also have to declare foreign sourced income. Now, assuming that a tax return gives a full disclosure to SARS of income being earned by the taxpayer, where those taxpayers wish to be viewed by SARS as non-residents,
Mm.
it's important to know, will they still declare foreign source income?
Mm.
And if not, why not? The two differences between, let's say, being a non-resident under DTA
Yeah.
and a non-resident under financial immigration is that one, with DTA, you can only be non-resident if South Africa has a DTA in place with that country.
Correct.
The return practically
Mm.
should still declare local and foreign sourced income,
Mm.
but the foreign sourced income would be communicated to SARS in a way where they are aware it is non-taxable due to the application of the double tax agreement.
Mm.
One could even say it's a bit of a cheeky approach
Yeah.
because you're actually disclosing to SARS, this is my foreign sourced income which you cannot tax.
Mm.
In comparison to financial immigration, you only have the obligation to declare what is local sourced income.
Yeah.
So anything that is foreign sourced need not be declared, because the understanding is this is an individual taxpayer who has ceased their tax residency on a permanent basis, and they may still have some ties to South Africa in terms of perhaps rental income, maybe interest income.
Yeah.
And these are the type of income that still need to be declared in the return, and taxes that are due to SARS should be paid.
Yeah. Okay. No, that's very insightful. I know there can be a lot of confusion. To take it a step further, I know that South Africa is lenient in a sense that not only does it offer the DTA or financial immigration, but there's also an exemption which one can make use. Maybe you can kindly take us through when this would be applicable, as opposed to doing a double tax agreement or financial immigration.
So I want to kind of emphasize that there are a lot of tax plans and options individuals can look into which suit their specific needs
Yes.
and align with their facts and circumstances. Having said that, for your typical expat who goes abroad from South Africa as a South African national,
Yeah.
you would have ideally 3 options to protect your foreign sourced income.
Yes.
Option 1 entails the circumstances of a taxpayer who wishes to remain a tax resident in South Africa. They will continue to file tax returns in South Africa aligned with that resident status. And when they declare foreign sourced income, they will claim a so-called expat exemption,
Yes.
which they can find in domestic laws in South Africa, section 10102, and they would be able to exempt their foreign employment remuneration. So not all foreign sourced income,
Okay.
only foreign employment remuneration.
So this does not include any rental income that you get from your foreign
Not at
property.
all.
Okay.
It's a very specific exemption and it has its limitations, but it's again aimed at that individual who's gone abroad for work,
Yeah.
for employment. And that foreign employment income is typically taxed in that jurisdiction they're in. And they are concerned that if I remain a tax resident in South Africa, having to declare worldwide income, SARS also has a taxing right on the same income. This is an exposure of double tax then. So you've got that option, and it's well suited for expats who have relocated for employment purposes.
Yeah.
Can be fixed term contract or permanent contract.
Okay.
And maybe they're not earning far in excess of 1.25 million. I think it's a very good approach to remain compliant and claim the exemption to ensure that you're not unfairly taxed. I would say option 2 and 3 for expats in the same circumstances, but perhaps earning far in excess of 1.25 million per year. We know that there's a very competitive market out there where countries around the world are looking for South Africans who are very talented, very experienced at what they do, very senior, and the remuneration packages that are being offered for these expats are very competitive.
Yeah.
So for those expats, they could look at options 2 and 3, which both entail updating their status with SARS from a normal resident to a non-tax resident.
Yeah.
The reason I say they have 2 options is because you either use a double tax agreement as the avenue in which you engage with SARS to verify the request and confirm that you're a non-tax resident. The effect then being all foreign sourced income is non-taxable. So that is broader than option 1 already.
Yeah.
Option 3 is to approach SARS with the avenue of financial immigration in mind. So this is, again, wanting to be a non-tax resident, But you've made it very clear at the outset when SARS verifies the request, you've got no intention to reside in South Africa permanently again. Broad strokes, recap, either Section 10102, the
Yep.
Expat exemption, Option 2, non-residency under DTA, and Option 3, non-residency under FE or Financial Immigration.
Yeah. Now, thank you for that, Delano. Now, I would imagine that obviously for those that are earning above the 1.25 million threshold, SARS is very much, gonna look into the intricacies rather. So there must be a lot that must be disclosed in terms of supporting your intention. It's not as easy as saying, "Hi, I'm leaving South Africa. Can you maybe just take us through?" I know the double tax agreement, there is a legal opinion that is considered. Financial immigration is more of a motivation letter. Maybe you can take us through the detailing of the legal opinion. What standing does it place when one makes that application?
It's a fantastic question, and it's one that listeners should definitely keep in mind. When you make a request to SARS to update your status from a normal resident to a non-tax resident,
Yeah.
surely SARS knows that there's something advantageous for them in this request as well. I think what is advantageous for them is that they have a requirement that the taxpayer must prepare a letter of motivation setting out their facts and circumstances in detail. This then gives SARS insight into a full disclosure of your asset and investment portfolio,
Sure.
as well as your mode of living in South Africa and abroad. Now, with DTA, it is incredibly important because the so-called tiebreaker test rules that come into play. To briefly explain it for listeners, DTA is starting from the premise
Yeah.
that a taxpayer is a resident in South Africa, but is also a resident in the foreign tax jurisdiction. And the double residence status that they hold is a conflict which needs to be resolved by application of the DTAs rules. The rules colloquially are referred to as a tiebreaker test because there is a tie in the residence status of both contracting states.
Yeah.
And it will look into where a taxpayer, for instance, has a permanent home, where their central vital interests are. That means personal and economic relations, as well as habitual abode. And the fourth one is nationality as a status. That's the one aspect I can foresee is important for taxpayers to keep in mind. I do think it is a prudent approach
Yeah.
that being so comprehensive with your request to SARS should be done in the form of a legal opinion. This is to withstand scrutiny from SARS on your filing position as a non-tax resident. So a Section 223 opinion, as legislated by the Tax Administration Act, is certainly the correct way in which to prepare that motivation. I would not encourage taking an approach of just opening up Microsoft Word and typing a story.
Yeah.
Remember, whatever you present to SARS is going to be uploaded onto your e-filing profile, and it will be there long after you hopefully achieve a successful outcome. And considering future movements, you want to ensure that that motivation is the correct synopsis of your factual matrix, and that SARS doesn't hold you to something which perhaps
Yeah.
puts you in jeopardy when you do return.
100%. Okay, I think on that note, what happens when one wants to return and they have ceased, their tax residency through the double tax agreement. Maybe we can just touch on what listeners are to expect should they come back, because I understand with the double tax agreement, it allows you that advantage to come back. It's not like you're cutting ties officially with South Africa, especially from a tax perspective, but what are the things to consider when one comes back after their wanderings?
This is equally an important question because what you are doing now is you're keeping the end in mind.
Yeah.
There are some taxpayers who are of the view that they can do the request to SARS themselves without professional assistance, and they are not too familiar of what are the intricacies of me having requested a non-resident letter from SARS
Yeah.
on the qualifying basis of either a double tax agreement or the ordinarily resident test, which is the equivalent of financial immigration.
Mm.
It's the qualifying basis of your request to SARS that will help you navigate the return to South Africa. What do I mean by that? What I mean is, if you requested the status update from SARS on the basis of a double tax agreement, you, in a way, have already told SARS that your intention is to return.
Yeah. At some point.
At some point.
Yeah.
For those who have gone abroad, for instance, on a fixed term contract, it's very clear when they're going to return at the end of the contract. For others, even if they've sought alternative employment opportunities, their first employment abroad is a fixed term contract. But maybe after that, they secure a permanent contract.
Mm.
There are still questions as to whether or not they will return. And their motivation, in a legal opinion, would then motivate to SARS upfront that you request a non-residency status. You certainly have not precluded the possibility of returning to South Africa. The key reason I see expats returning is for retirement. When it comes to financial immigration,
Yeah.
this is a far more delicate situation that needs care and precision,
Yes.
because one cannot return to South Africa and request that SARS reinstates them as resident taxpayers
Mm.
on a basis of their facts which contradicts the initial request.
Mm.
So, as a default position, SARS would say, you have signed a declaration to us that you are non-resident because you are no longer ordinarily resident. In other words, and it is an oversimplification, that you no longer consider South Africa your permanent or real home. So this does raise questions if you do return.
Mm.
And you wouldn't want a skilled SARS auditor after 10 years, for instance, to remind you that you signed that declaration
Correct.
and put into question all the tax returns that have been filed subsequent to your exit
Mm.
on a non-resident basis, albeit only declaring local sourced income under FE. SARS could then challenge you,
Mm.
and you open yourself up to the risk of back tax.
Mm.
So choosing the correct basis
Mm.
is very important from the get-go. And I would encourage listeners
Yeah.
to at least have an expert's ear in mind to listen to what are their circumstances and what are their financial goals as well. Because their financial goals might mean that the final destination is abroad, or maybe the final destination is still in South Africa.
Correct.
And if it is still in South Africa, it's a beautiful country. I would very strongly recommend exploring how DTA can perhaps assist them with temporary non-residency.
No.
It's a basis recognized by SARS. It is international tax law, which is built into our constitution as well.
Yes.
And it is very much a legal basis and justification for their request to be non-residents, albeit with them wanting to return somewhere in the future.
Yeah. No, thank you so much, Delano. That was such an insightful, podcast. I think there are things to take note of. And if I can close off, it is very important to get in touch with someone who is like Delano, who's very seasoned in what he does and very passionate, as you can see, especially taking into consideration this filing season. I know SARS is taking a lot of precaution, so you need to make sure that you are filing under the correct tax status. So get in touch with us. Do connect with our legal manager who will guide you and make sure that you are protected and your foreign income, and most importantly, is protected. Thank you for joining, and hopefully you'll have a second session.
Thank you, Mbalenhle, and thank you to the listeners.
Thank you, Delano.